I'm very happy to be here to moderate the first panel, and I want to extend my own word of welcome to all of you. We're very happy to be hosting this meeting, and I look forward to learning a lot from the panels that Frank and his friends have organized. And the learning will begin with a distinguished lineup of panelists here with us this morning. They've been asked to address the questions set forth in the description of the panel here you have in your program, and have been given a generous 10 minutes each to do so. That will just prime the pump of the discussion. That's the whole idea, I take it. But the essence of the questions is captured, of course, in the first sentence of the description. What are the objectives and contents of the basic course in comparative law? Before giving the floor to our panelists, I'd like to take just a moment to reflect on my own experience in teaching comparative law. As a young law professor, I was delighted to learn that I had been given the opportunity to teach the course. I lived for 2.5 years in Germany. I spent a year at the Max Planck Institute for private international and comparative law in Hamburg. I had gotten a doctorate from the University of Cologne. I spoke the language. How hard could this be? I basically should just be able to show up and let Rudy Schlesinger's book do the rest. Wrong. This was one of the hardest classes I have ever taught, and it didn't get a lot better thereafter. So hopefully our panelists will help me understand where I went wrong. I will introduce each of them very briefly before they come to the podium. I'll make an exception for Judge Lokar, since he is visiting us from afar and is not an American law professor, although one sometimes might think he was, because he has visited us here many times as part of our International Jurist series. So I'll begin with Judge Lokar, who really is a Renaissance man of international law, in the sense that he has one foot firmly planted in each of the fields of public and private international law. I think he started in the field of private international law, as a matter of fact. Yes, he admits as much, which is what I did as well. So we're delighted to have him with us. He comes to us for the International Criminal Tribunal for the former Yugoslavia, where he has served for a number of years. He's also a member of the law faculty at the University of Milan. I don't know which, maybe I should call you professor. Is that higher title than judge? I'm not sure.
I don't know.
Yeah, well, anyway, I will address him as Judge Lokar. So please join me in giving a warm welcome to Judge Lokar.
Thank you, Steve. It's a great honor to be here in this gathering of high-level experts in comparative law, and it's a little bit in difficulty because I'm not a scholar in comparative law. I'm more a practitioner of comparative law, because in fact in my court, when we have to assess customary international law in criminal matters, means essentially working on principles and comparing principles that you find in different systems, and take out of the systems what may be common trends, common approaches, and decide on the basis. That's why it's clearly a comparative methodology that frequently we follow, as it is the case always in international law, when the source of international law, that is common principles to states, comes to play. It's very difficult to work on principles that are really international. One has to work on domestic principles and compare them. So I will try to give some perspective of how a basic course should be. Bearing in mind that a basic course should, in all law faculties, be followed by special courses. A general course will not be enough, also because it will be necessarily based, at least so it is in Europe, at the beginning of the first, second year maximum, when students do not have any knowledge of law. So it will be just an introduction to law. And sometimes for many students having an introduction to law, that it's an introduction to many systems, confuses their mind. It's difficult to appreciate other systems, the value of comparing the system without not having any principle in mind. In the old times, when I was a student, it was slightly different, because in those times we had exhaustive teaching in Roman law. And in fact, we started the studies with Roman law, with a lot of Roman law, hours and hours a week of Roman law, which was very important from the comparative point of view, because compare is not only horizontal, but it goes historically. And one, to understand the systems today, it is necessary, in my view, to have a basis in Roman law, at least for certain systems. To understand civil and common law is essential to have a good basis in Roman law. This, unfortunately, in many universities in Europe is now missing, which does not detract from studying comparative law, but it's one component that is probably missing. I don't teach comparative law, but I have seen, looking at the programs in European universities, that the basic principle, essentially, it's frequently very traditional in the sense that it goes to the theories of comparative law, Zweigert, David, and remains more or less in that framework. That makes the course very much Eurocentric, which today might not be a good idea. In any case, it's not enough. Makes the course very general, while I think that even a basic course should identify areas, specific areas, work on those areas, to draw principles from those areas, not just give to students some general perspective, which would not be very helpful to them. But it's understandable that in Europe this is the trend because of the European Union, essentially. The European Union is an instrument of comparative law, because it has a big program in harmonization of the law. And inevitably, harmonization is based on comparing different systems and try to put them together to find a common denominator that could work for all of them. It was difficult already at the beginning of the European community, when the community was just comprised of continental states. It became even more difficult when the UK joined the Union, and UK and Ireland, and brought in common law. But it would have been far more difficult if an American common law would have come in, because the British common law it's relatively continental in my view. The origin based on Roman law is very much the same for continental, except for the German influences clearly, but the for the continental law and the British English common law. So the fact that the European Union is there, and also that there is work in the European Union, we should not forget the market. Students are happy to work on these matters. European law is one of the courses that has more appeal, inevitably. Students want to go to work in the European institutions, and so take with interest courses, also comparative law, that are restricted to the European perspective, which, in my view, is not correct. Wish to do an effort to have courses with a wider perspective, because it's also wrong that the European Union remains closed in itself. There is a strong tendency of the Union to work inside the Union and not to give enough attention to the outside world. This is visible in many fields, and sometimes. But coming back to teaching, indeed, there is this tendency to probably not a trend, actually. It's more a fact, or the absence of a renovation of the studies to remain essentially in discussing the differences between continental law and common law, which, of course, is an important topic. We know it, and we know how difficult it is to blend these systems in all fields of law. But still, it's not the only problem. If we look today at globalization, if we look at what international bodies, also judicial international bodies, take the appellate body of the WTO, are doing in international commerce, and they are based frequently on comparing systems and trying to find a solution of this. So my preliminary answer to the questions you have input is that courses are now, in Europe at least, too restricted, and the basic course should be more open to other systems, trying to find a better approach to deal with this global problem. I don't have the answer to answer the other questions that are in this, but one thing I would say is that the goal of the course should not just be to give a general introduction, but should be to give the students the sense that law is not just one law, and that there are several laws. There is a cultural dimension of the law, and one has to deal with this cultural dimension of the law. It's important that that perspective comes to the student. It's true, most of the students will later be practitioners in their own system, and sometimes they will never care for comparative, but you should know that there are other values, other systems that are equally important. The approach to different systems should be an open approach, because the basic is that all the systems try to do their best to regulate the life of a society, and when they come into contact with various systems, it's important that those who work in one system do not try to remain inside and take what is good from the other systems. Well, these are just preliminary remarks. I will not say more for the moment, but hope there will be a lively discussion later. Thank you very much.
Thank you very much, Vasto. Our next speaker is Padida Alai. She tells me the I at the end of her name in the program should actually be lowercase. Bill Gates intervened and made it an uppercase I. So if you want to correct it on your programs, I'm sure she will welcome that. She is from American University, Washington College of Law. And I will leave it at that because you can all find out more and will, I'm sure, during the course of the meeting.
Thank
Welcome.
you very much.
You're welcome.
Yes, I am a victim of Microsoft. That's my name. It does that to me too. Every time I write my name after the apostrophe, it just capitalizes it automatically. It's autocorrect. I want to, I feel it's an honor and a privilege to be here. In terms of full disclosure, I must say this is the first time I'm attending the Society, Is Comparative Law meeting, not because of not wanting to, but I have circumstances that I will shortly explain. So I want to thank from the bottom of my heart Frank Roberts and McGeorge, the Dean of McGeorge School of Law. My colleague Fernanda Nicola was the one that was supposed to be here, but I took advantage of the opportunity of her absence to join you and start a journey, or sort of move on a journey that I started 24 years ago, not that long, when I was in law school. My area of teaching and scholarship has been mostly in the area of international economic law and WTO law and international business transactions. But as you may expect, interestingly enough, my approach to comparative law is not particularly influenced by that. When I started to teach comparative law, I asked to teach it. There's been a great reluctance. It's been 14 years since I've been able to teach it because I get so many students in my WTO law and international business transaction questions. Why? Even my dean, who is a comparativist himself, said, "Are you sure you're going to get enough students?" Because I'm used to have 70 students. Why? What exactly is causing you to want to do this? And this is where I want to tell you the story of why I come to this and what comparative law means to me, because I think what is comparative law is very much in the eyes of the beholder. And in terms of my experience in WTO law, for example, I have been impressed by lack of connection between comparative law and comparative legal scholarship and the work of the WTO that is most starkly about promoting a particular vision of an administrative regulatory state. And that there just isn't as much as one would hope, and I think some of my colleagues who do work in that area would agree with this. In fact, when I have been in settings with former trade negotiators talking about reforms of the WTO, and I make comments in passing like, I would be interested that when we look at the Chinese protocol of accession and the word transparency, really, is there something that we can, has there been any thinking of sort of history and culture and comparative sort of work into what does transparency mean within that context? And I get laughter from the group, including from my Asian counterparts who are from the University of Singapore. So, in fact, sometimes they're like, you know, this is a very Western thing to want to talk to us about, you know, Confucian thought or we are not that different. Let's just, you know, that it's immediately dismissed. So we don't want to create ourselves as the other. You're building an international organization. That's the process. First, let me talk about. So it has been difficult. So there's a bridge that is not there for at least me. First of all, when I entered Harvard Law School in the fall of 1986, I had been in the United States for about 6 years on what I call the Khomeini Scholarship. That was, we had the opportunity to come to the United States. And one thing that struck me very, very early on, my first days of law school, was how I was not in tune with why law was so important to my classmates. How I didn't really relate to the visceral reaction people had to in the area of criminal law, for example, search and seizure and constitutional law and all of that. It was like a basic right of, you know, Miranda rights. There was all this discussion. I actually didn't even know what the word litigation meant, even though I had studied English literature, thinking the word litigate was alien to me. I remember thinking about that, and those has stayed with me. I felt very alone. I felt intellectually alone. I just did not get the passion. It wasn't that it was not international, it was, but there was something about, as I said, understanding of how people relate to law, the sacredness of the Constitution, things that was going on here. There was a disconnect between what I felt myself and the rest of the class. So I was with great enthusiasm looking to my second year and to take a course in international law, which I did with H. Chase at the time. H. Chase became a mentor, a good friend, but international law was not what I was looking for. It was about international institutions. It was sort of up there. It seemed somewhat disconnected. It didn't work. So at that time, Harvard did not have a course called comparative law. Marianne Glendon had not joined the faculty yet, was about to. There was Arthur von Meren's class on civil law systems, which I took. Then we had Professor Butler was visiting from School of Oriental and African Studies on what was then the Soviet or socialist legal systems. I took that. It was all based on case method. Somehow it wasn't doing it. I had certain expectations of these courses, and it wasn't fulfilling this visceral need that I had. I remember in the socialist legal system, we kept looking at cases, and I was looking for big pictures, like what is going on in the Soviet, what is going on in society, how do people relate to law. They were interesting cases, but the case method approach was making me very, very upset. And I was a student, I didn't know where to go. I went to the Center for Middle Eastern Studies. There was no Islamic legal center then yet. Frank Vogel hadn't joined Harvard. And I started studying some Islamic history. And that's where I actually started to find more. Not that obviously I had escaped persecution. I didn't come to study Islamic law. So I used to tell people I want to study law so I know if I'm going to be condemned to death exactly what's going to be the grounds. No, it was joking. But I basically wanted to understand what motivated, how people perceive the rule of law. And it didn't it was wonderful, but it was outside the law school till Frank Vogel came, and then I started studying Islamic law, which was, again, I think, interesting to me. I took 3 or 4 classes, but it was a lot of detail about Islamic law, and some point Islamic finance, which I found fascinating. I wrote my 3rd-year paper on, but it exactly was not a comparative law course that I was looking for. Eventually, I saw Professor Glendon. She had just arrived, and I said, I want to be a comparativist. This is now 1988. So I wasn't able to take a class with her. And I don't remember the conversation in detail, but my feelings I remember very clearly. When I came away from my conversation with her, it was, you need to drown yourself and get really in-depth knowledge of a particular legal system in order to, maybe get an advanced degree, get a PhD. Especially, I think they were thinking Islamic law for me at the time, perfect your Arabic. And I think it was all true, but it was not possible for me. I had financial considerations. It was not possible for me to go and get a PhD at the time in Islamic legal studies. So I went to practice law. I ended up in big law firms. I did international trade, international business. So when I came into academia, it made sense because that's what I had done, that's what I knew about, that's what I wrote. But comparative law was always something that, now my understanding of comparative law, not necessarily the classes that I had taken, even though I had taken bits and pieces, I somehow wanted to put it all together. And the opportunity really didn't come to me till last year, when I first started to teach this course. And I came to, as I was putting this course together, I came to the conclusion that I want to talk about my journey. What was it that I needed to hear in those years? So I'm coming at it from a very subject, and I wasn't getting in the curriculum. And it doesn't have much legal content in terms of hardcore back letter law. The course materials that I use, I take some from the Schlesinger book, the Merriman small book with Perez Perdomo on civil law tradition. I think it's wonderful to have that. I do Patrick Glenn's book on the legal traditions of the world, and because I know more about Islamic law, introduction to Islamic law by Joseph Schacht. I take certain portions of that as well. But this is how I have decided to look at it. Comparative law for me means trying to move towards a just society and understand how law interacts with society. What do people understand about, and also the limitations of law. This is how I write the course. The course will begin with the question, what is comparative law? The answer to this question would largely reflect the worldview of the questioner. The aim of this course is to assist us in situating our own legal system within the broader global framework and to allow us to be self-aware and self-critical, and perhaps moderate our own views about what the rule of law can do on a global scale and how law is perceived, even an individual or group's worldview, as molded by history and circumstance. Is there a divergence among legal systems? Is there a convergence? How has the discipline of comparative law changed in response to globalization? What role does comparative law play in the workings of international organization? What role should it play? What does the study of religious legal system tell us about quote-unquote secular ones? Or what the study of religion or moral code tells us about attitudes in different societies towards law? I put in everything in there. I can imagine it's quite very, very broad. It's a work in progress. This is why I'm here, to hear your feedback. And it's a bit dilettantish, because people tell me, what gives you the right to think that you can actually teach topics that you know not that much about? I mean, I do Western legal traditions, I do civil law tradition, I do the common law tradition. I had a Jewish law. I had a wonderful friend, a rabbi, came to speak about what he teaches in Jewish law classes, in studying the Talmud. So giving the people an understanding, starting with one very simple example. If you have something thrown on the floor and you don't know who it's from, do you have an obligation to find it? You know, what is the reasoning? How different approaches work? I then moved from there to Islamic law, which is great because there's so much parallel between. And in Islamic law, my idea, this is something that is not to give an overview, but I basically pretty much want people to understand the tension between codification, because we tend to believe that codification means sophistication. And then moving towards more rule-based means it's a more sophisticated society. And if you look at the history of Islamic law, the minute they started codifying is a minute that you can carve off its demise. So there's this tension between closing the gate of ijtihad, as they call it, the interpretation and keeping it open, flexibility versus immutability. And this is then, I look at sort of some of the sayings of the Dalai Lama. I do something on Buddhist law, which talk about what is dirty law, the attitudes towards law, what makes law good, what makes law bad, the Confucian sort of antipathy towards law, the legalism. You need law when the moral code doesn't work. So I do a little bit, and I also look at Hinduism, the issue of sort of karma, and the idea that that you will have to live again, and what you do in this life affects what you do in the next. So it's a very. I had travelers in the class. I had 11 students who liked to do what I was doing and studying with me. I do not imagine, it's an experiment, that this is going to work in every class with every law student. I mean, I think some law students will be self-selected and will drop out of this. But those who were there were like, this was incredibly good experience for me. It just a few of them said, it gave me what I wanted in law school that was missing. There was something that was missing, and it gave me a different perspective of the role of law that I didn't have before. But it's risky, and I'm talking about things that are faith-based, so there's a lot of personal risk in there to bring that up and have a conversation about it. I can't really talk about the details of it because there's so many issues, but I just want to give you a general overview of what I'm trying to do, but it's a long way coming, and I appreciate your help. Thank you.
Thank you very much, Fabita. And finally, we have Peter Winship, who's known to many of us from SMU Dedman School of Law. I don't know that you need any more introduction, Peter. I'll just say that Peter also has a McGeorge connection, having come to our program in Salzburg a number of times. Welcome, Peter.
As you can see, I'm not Jim Whitman, who was the original speaker on the panel. And I was asked, Frank was very frank with me. He said, it is because you are preparing, together with Louise Ellen Teitz, a casebook in comparative law. And would you therefore say a little bit about our casebook project and the wrestling with trying to decide what goes in it? And I'm delighted to do so. I have to say that he also added that I only had 10 minutes to do it. And I have to warn you that in Texas, minutes are much bigger and longer than others. And he ended it by saying I had to be provocative as well. So I've been puzzling about this provocativeness. In any event, I'm going to talk first very quickly about certain assumptions I made as I prepared the talk. Second, I'm going to talk about the constraints that are placed upon preparing any type of course or materials. And finally, I will thirdly talk about the project itself and what is involved. In terms of assumptions, I'm assuming, unlike my colleagues, that these materials are to be prepared for JD US students, not a core course that would be taught in Europe or even in England, where I also teach occasionally. I am assuming just US JD students. And secondly, I'm assuming that you are all familiar with Matthias's piece in the 1996 Forum Tulane European and Civil Law Forum, where he discusses the question of what should be done. And of course, that was a lead-in to some of the projects, including the McGeorge project, as well, of course, as the proposal at Michigan. I don't want to repeat it. It's an excellent review. It's where I went immediately after being asked to be on this. I would only qualify it, as I will say later, when it comes to some of the assumptions he makes in that, or assertions about the constraints that we operate under. The third assumption is that we're operating under the Chatham rules, which is to say nothing said here is to be reported elsewhere. And I mention that, in fact, because there is the golden rule that co-authors always make the mistakes. They're not your mistakes, it's the co-author's mistakes. And I don't want my co-author to know that I have said certain things. So, in any of that,
Chatham House rules.
Chatham House rules. So much for constraints. I think Matthias in his piece lists a number of these constraints, and I would roughly divide them into law school constraints. And then when one talks about actually publishing materials, you have to talk about publishing constraints and the constraints placed upon it by the publisher. Within the law school, of course, there are constraints of the students. You have an audience that you're trying to address. Matthias, I think, makes some obvious points, which he says we all know what the limitations are with respect to language, with respect to a background, etc. I don't want to repeat them. I would only suggest that, in fact, there is some variation between the law schools. We forget that some law schools are very regional and may have very different culture in their particular law schools. And so I don't know that we can generalize about law schools broadly. Secondly, I would also suggest that many of us have LLM programs, and that is a variable here for not only the classes, but also perhaps for the teaching materials. And I have specifically excluded those from the discussion of the materials we're preparing. Matthias also mentioned certain faculty constraints. Although I would elaborate on them, I think he underplays the difficulty there is unless the law school as a whole in curriculum review is willing to stand behind the dispersal or devolution that he argues for in that piece. And not all law schools do that. And that, of course, means that you do face the traditional model, which is the one that he complains about, and that is that in most schools, there is a single faculty member, the comparatist, who in effect is allowed to teach a course on comparative law without any true faculty or curricular committee supervision. And I go back to my experience. Peter Schroth was the comparatist when I, in fact, joined the faculty. And I was taken aside, even though I didn't have quite as impressive background as Steve did. What happened was that I was told, don't mention the fact that you had been in Ethiopia for 4 years. Don't mention the fact that you had studied at the London School of Economics. Don't mention your interest in law and modernization at the Yale Law School, where I had done some postgraduate work. Don't mention any of that. Teach your commercial law classes. Teach your corporate law classes. And because I was the most junior person, I also had to teach trusts, as Peter may remember, back in the days when it was assumed that any of us who joined the faculty could teach any of the courses. In any event, that has changed, I'm sure, but I still think the traditional model is that we go out and fill a slot, which is known as the comparative law slot, and a course will be taught on comparative law, and that's what I think Frank in his description here is talking about as the basic course, and I can now reveal the outcome, the provocative comment, which is just as Gertrude Stein described Oakland as there being no there, I would suggest there's no core there when it comes to the question of what is taught in this basic course. It basically turns not on curricular concerns, but who it is that is teaching. That is a personnel question, what their background is, etc. So I think faculty, the question of constraints on faculty is an important one. Things have changed. Junior faculty members come in often with a rather blurred idea. They include international, comparative, and they sort of lump it all together. And certainly the students will look in the list of courses and they will be attracted not so much by comparative law, although that begins with C. They jump immediately to international law, which begins with I. So I think there are constraints. Curricular concerns also, I think, are a constraint because some faculties have much greater freedom to teach what they would like to teach than in other faculties. And I think this is something one has to take into account when one tries to think of courses beyond this, quote, core course or basic course. I would only mention that at SMU, we got around the basic course. I teach it only when our comparativist, the replacement for Peter when Peter left, he's been there now for 30 years, and only when he goes on sabbatical do I teach it at SMU. It's when I visited other schools that I actually teach comparative law. But I have managed to get around this, much to the concern of the dean, because we created in our curriculum a wild card known as Comparative Law 2, which in effect is supposed to be building on this non-existent core course or basic course. And I have for years taught what I now call transnational commercial law, which has its own traditions actually coming out of England, where transnational commercial law is part of the course book that Sir Roy Good put together, known as the Good Book, of course. And we, in effect, deal with that. So I think there are curricular, faculty, and student constraints. When we turn to publishing, we have a contract with West to produce a comparative law casebook. We entered into the contract, as someone reminded me yesterday, in about 2006, or I think it may have been 2005. We had been talking for some time. My co-author and I had agreed. We talked with a number of people to join us on this project. But we had an idea, and most of it was sort of negative. We were both tired with teaching comparative obligations. We wanted to build on our strengths, which were generally in the area of civil procedure, but we didn't want a comparative civil procedure book, for which there are now several books, and it's very important, but we wanted in effect to take a subject matter which we felt had been, at least at the time, it's now, we have, I think it's annual international conferences in this area, but at the time it was sort of underserved, just as public law had been underserved. So we, in effect, it was somewhat negative. It was reacting to existing materials which we felt were somewhat tired. The fun of working on these particular projects, of course, is trying to work out with your colleague what goes into it. And Ed, who is her colleague in Rhode Island, knows that the pile of materials that we were trying to do had to be packed up in a huge number of boxes that are now stored, because she recently joined the Hague Conference on Private International Law Secretariat, which may slow up the project a little bit as we work on it. But the huge pile of materials had to be reduced. And as we worked on reducing the pile, preparing notes, what happened was that we began discerning a theme. And that goes beyond it. And I think the best way to approach it is to just add a couple of comments about the law publisher requirements in the contract. The number of pages are limited, as you know. You can't have what we would have liked, 2,000, 2,400. We had to settle on 480. And we had 12 topics as we worked around it, and 12 into 480 is 40, and 40 pages per topic is very limited. I'm told I have 1 minute to tell you what's in the 480 pages. Let me just summarize. First, West is publishing it. There are 12 chapters. It's due as a manuscript at the end of next summer, if we're lucky. It's divided into 4 segments. There is an introduction, which basically sets out a couple of readings, David, Legrand, because the theme that developed, given our backgrounds, was the question of transplants, convergence, harmonization. And we're not proponents, although we have worked with Untitled and Unidwa, she with the Hague Conference primarily, but also with the other institutions, the lawmaking institutions. And of course, I am familiar with the ICC work as well. So the introduction tries to introduce some of the themes that we limit, the way we organize subsequent chapters. The second part deals with legal education. I got tired of my students saying they'd never heard of the Erie case, even though it may have been the second and third year. And so I said, what is it that they know? They refuse to talk about contracts in the comparative obligation course. So I said, legal education, they know about it. And I give them an Alan Watson piece. We, in effect, there are 2 chapters. The first chapter is US, Alan Watson. Second, we take the traditional German legal education model. The third is the Japanese experience, which over time, I was excited because they were, in effect, changing it in order to have a much more US-based system. And over time, we've discovered it's been a total disaster. And so it's a very useful discussion of that. Second of the legal education chapters, I'm sorry, they're very big.
Big minutes.
Big minutes, yes. Second chapter on legal education, we broaden it out. We deal with socialists, namely China, the obvious socialist one. We deal with the question of Islamic law, where in effect what we don't quite go into the Sharia, we try to show that formal legal education is often divided between the two. So we've got some interesting questions as to where the codification as opposed to Sharia works there. Third is, with my experience in Ethiopia, we take on what was a very instrumental and very detailed study that they did in developing their legal education system. We, in effect, take an excerpt there for a developing country, in effect, to try and see what they're going to do about legal education and preparing people to work there. That's the second. The third, dispute resolution, a number of chapters. I know I'm overrunning. What we did in each of these chapters is we started with a segment or reading on US law. And we typically chose a relatively narrow topic, legal aid, for example. US doesn't exist, basically, certainly not in Texas, but anyway, legal aid. We then took UK, which is now debating, because they have no money, they tell us, they're debating a very liberal legal aid program, and then we, in effect, talk about harmonization. To what extent, for example, do the Hague Conference treaties indicating that you must have legal aid in implementing those treaties, to what extent can you, in effect, through an international instrument, do it? And that is the pattern. This US, to make sure that they have a basic, they can't deny that they don't know anything about it. Second, a foreign, and I'm afraid we're rather eclectic as to what foreign system, and then an attempt to bring it together and talk about whether harmonization projects actually have worked in this area. I can't go on, but I would then, there is in the fourth section, 2 chapters, basically divided among us, between us. She is going to prepare a class actions chapter looking at functional equivalence of class actions to our US system, and I'm working on comparative insolvency. We did this at the end because we recognized that, which is procedural if you think about it, as well as substantive. But in effect, what we were trying to do was to prepare a book that could be used not only in a basic course, but also could be developed by others. West has very kindly agreed to say all those materials, if we digitalize them, we can put on a supplement on the web, which unfortunately would be open to everyone, so you could steal our attempts at intellectual property. But basically, we, although constrained to 480 pages, have materials, and in selecting them, we're basically also putting these others and making them available to instructors. Thank you.